First, let me say danke wel to the university for inviting me. I'm very honored to be here. Law is not a modern scientific activity, it's really ancient. And so I'm not going to have any slides for you today. I'm just going to talk with you. And I'm going to talk with you because one of the interesting things about the science that we've seen so far, the wonderful work that's been done, is that it seems to me always to leave a question. Who is going to decide? Who is going to make these decisions? And sometimes we think it should be the private sector that makes these decisions, and sometimes we think it should be the public or some link between the two. And my life has been involved with constitution building. And so I'm going to look at it a little bit from the perspective of if we're going to think the next 40 years of the University at Hasselt, are we going to think too about what are the challenges that the world faces in decision making in the next 40 years? For me, those challenges are threefold. It's about interdependence, it's about autonomy, and it's about pluralism. And I will finish with those. But if we think about some of the problems, if you think about the question of economics, today we see the rise of the BRICS, Brazil, Russia, India, South Africa. This is a new world that's arising. It's not arising because it's producing, it's arising because it's consuming. Right? That's the power of this particular group. And China, of course, is one. And that's a concern, because if we see the talk about population and about consumption on the earth, if these countries are going to reach the same level of consumption as North America and Europe, can the earth tolerate that? That is a serious question. If we think about the environment and climate change that's ongoing, and finally if we think about conflict. We have Syria today in conflict. How are we going to manage the conflicts over resources, over governance that arises? So the first level that I want to talk about is the question of nations, nation-states, and governance in this global societies. The problem with this is that it collapses the idea of nations and states. States are about government. Nations may be something slightly different. And it's a problem when we always talk about nation building. In Africa, we talk about nation building on top of borders that were given to us. They're not borders that we made ourselves. And so, what is it to create a nation in one of the borders of post-colonial Africa? We are plurinations, is the nature of the states in Africa. Every one of them has many nations. You in Belgium are well aware of a plurination, right? This is a reality we live with. And it's something I think we have to take on board rather than think we're going to build nations. The ridiculous thing the US tried to do in Iraq, nation build. Disastrous. If we think about this process of nation building, or in a plurinational context, the process of trying to build a constitution in a state-based system within certain boundaries, and particularly when we move from conflict forward, we have to think about this first as peacemaking, as coming to some resolution of conflict, and then of constitution building. And one of our problems is we try and collapse those two things together. It's a problem that we've partly created even in South Africa today. We have reached the first step of peace, and then we said, okay, now we do constitution right away, which is correct, but now we also start locking certain things in place and not addressing some of the issues that we needed to address for a future. And that raises the question of democratic governance and state capacity, because we of course believe in democracy. And if democracy is everybody just deciding together, does the majority win every time, in every place? And what does that mean, particularly in relation to the capacity of a government or a state to deal with this? Well, if we look at governance or accountability, it also raises the question of at what level? What is local autonomy? We've moved from the idea of the non-interference in the domestic affairs of nations, which we started with in the UN Charter, to the idea of responsibility to protect. If a nation cannot protect its people, we believe there might be a right for the international community to intervene. So, local control and yet international accountability. What does that mean in specific examples? Well, if we decide to resolve a problem in one country with amnesties for gross violations of human rights, what does the international community say? Do they take the same people to the International Criminal Court and say they have committed crimes that the world cannot tolerate? There's a tension. We can have a Truth and Reconciliation Commission and think we've resolved certain issues. Maybe we haven't resolved them. We've just got a peace for the moment. We celebrated the emergence of the Gacaca in Rwanda post the genocide. That will resolve it. But when we looked a little closer, that local justice may not have been as much about justice as settling local scores. If we look at the International Criminal Court, we say it's good that we have this international court to resolve issues, and people in Africa say, it sounds like the International Criminal Court for Africa. Where are the others? Are there no criminals in other places? It also raises the issue of legal pluralism and a European term, subsidiarity. In that legal pluralism recognizes that we have multiple sources of law. And the problem then is, what should apply where? Where should the decision be made? At what level? The Europeans have this concept of subsidiarity, that it should be applied at the level where it's most correct to apply it. Who decides that? That turns me finally, because I was told only 15 minutes, to institutional limits of legal pluralism and justice. We all have, and we've seen in these talks, identities, cultures, solidarities. And if we recognize that there are different sources of law, there are also different institutions, alternative institutions. Just at one level, in terms of international business, they operate with a lex mercatoria they're happy with. They operate with, in the system of alternative dispute resolution and arbitration. And that takes a lot of resources, and it's a private-to-private activity. But where does the public come into this? There's also the promise of regionalism. Can this be intermediated between the local and the global by some kind of regionalism? Will that help us? Now, I'll think about Africa briefly in this regard, because we have regions that have emerged in Africa. We have the Southern African Development Community as a region, which started first as a group that was opposed to apartheid, to help with the struggle against apartheid, and has now developed supposedly into a development region. We have ECOWAS in West Africa as a regional group. We had before an East African community that fell apart. One of the interesting things about the two that have survived is that they have natural hegemons. Maybe not natural, but they have hegemons. They have Nigeria in ECOWAS and South Africa in SADC. And that raises immediately a problem. If regions are going to intermediate between the global and the local, what does it mean when you put a hegemon in the middle? Are they now framing that intermediation between the local and the global? And sometimes they do. Nigeria has at times through ECOWAS been very interventionist in West Africa. South Africa has been a little less interventionist in Southern Africa, although it seems to be going further north all the time in very problematic ways. But the Southern African Development Community Tribunal, so if we think about legal institutions, the idea that we can create courts at this intermediate level, and you have long experience in Europe of this now. But in Southern Africa, we're very hopeful with the creation of the Southern African Development Committee Tribunal to resolve issues. And then the issue arose of the question of land in Zimbabwe. And when that issue reached the tribunal, the answer by Southern Africa was to suspend the tribunal. That tribunal presently is in suspension. It's not working. So it's not clear how easy these regional level is going to be able to operate to resolve these problems. There's another problem with this regional level, particularly in Africa, and that is the cost. And actually, you can think about that at both the international and the regional. Already we are complaining about the cost of these international justice systems, how long they take in individual trials, and the cost that this bears. Who's going to pay these costs? Who's going to carry this? Is clearly a problem that we have. It is clear then that we are interdependent at all these different levels in our decision making, but we want local autonomy. We want the right to decide for ourselves at the most local level. And we have a form of legal pluralism in that at every level, wherever we are, there's these different parts of law that are applying, whether it's international law, whether it's regional law, whether it's local law. And we have to learn to make these fit together and make them relate to one another. And I'll leave you then with the challenges of 2053, not the resolution. Thank you.